In a stunning legal twist, a judge has just tossed out all 12 claims in the high stakes lawsuit brought by Justin Baldoni, the actor, the director, and by his company, Wayfarer Studios. The case was against Blake Lively, Ryan Reynolds, and the New York Times. The case centers on a film called It Ends With Us. That's a film that Lively starred in along with Baldoni. Baldoni was both the co-star and he directed it. Wayfarer and Baldoni say that Blake Lively hijacked the entire production, made threats, defamed them in the press, and pressured Baldoni's own talent agency to drop him. But the court is not buying it, at least not yet. There are two claims that might still survive if Baldoni can come back with stronger evidence. Here's what the judge said and what could happen next. Now, the court dismissed the claims. Let's talk about what that means to lose a case at the motion to dismiss stage, because it's a little different than what you might think. Now, at this point in the lawsuit, nobody has taken the stand. There has not been a trial, there's been no discovery, there are no witnesses yet. The judge is only looking at one thing, and that's the complaint, the document that got filed with the court saying, here are the claims. It's the very first document. The plaintiff, which here would be Baldoni and would be Wayfarer Studios, this is where they say why they're suing. The question that the court's going to decide, does this complaint describe a legal claim that's possible, that's plausible? Here's an example. If there are three legal elements to prove the claim, are all three of them sitting right there in the complaint? Did you at least mention them? And if you did not lay out the claim, all elements, or you didn't lay them out clearly, your case, or at least that claim, could get dismissed. At this stage, all you have to do is survive to the point where you can get discovery and where you can lay out the actual facts that support everything. Because what's written in the complaint is largely in your control when you're the plaintiff, you get to write down, you get to describe it. It's unusual to get your entire complaint dismissed. It is very common to lose part of your complaint at this point, where the court will say, I'm not going to let you have this claim or that claim, but it's unusual to lose every single one. But that is what happened here. The court dismissed all 12 claims that the Wayfarer parties brought. Some of those were against Lively, some against Reynolds, some against the New York Times. Lots of them were against more than one party. But that said, it's not entirely over because the judge gave Baldoni's side permission to amend two of the claims. Now, ironically, they're probably not the two claims that Baldoni would have chosen to keep. But let's break them down and see what it is. As I mentioned, there were 12 claims, and the court broke them down into 6 categories. So we'll cover each of the 6. The first was civil extortion. And the core allegation here is that Blake Lively used her star power to strong arm everyone into giving her what she wanted. After the actor's strike ended, she allegedly said she wouldn't return to filmmaking unless they met her demands. And she threatened not to promote the movie unless they used her edit. And she refused to attend the premiere unless Baldoni was not allowed to come. And she allegedly even warned she would go public if Wayfarer would not accept blame for the problems on the set. So Wayfarer said this is extortion, not blackmail, not literal blackmail, but civil extortion under California law. That's not usually a claim you can sue over unless someone was forced to hand over money or property under duress. And that's the problem. The court said, look, this was bargaining. This wasn't extortion. If Blake really violated a contract by refusing to promote the film, then Wayfarer had something it could do about it. It could sue her for breach right then and there. And instead, they gave in, and now they want to call that negotiation civil extortion. The court said, yeah, I'm not buying it. The second claim, defamation. We all know that defamation hurts your reputation, but under California law, it's more specific than that. You need a false statement that was published and is defamatory. It's not privileged, and it's either naturally harmful or it caused actual damage to you. When you're a public figure like Baldoni is, you also have to prove actual malice, which means that the person who said this statement about you knew it was false or acted with reckless disregard for the truth. Here's what happened in this case. Blake Lively filed a sexual harassment complaint with California's Civil Rights Department and allegedly sent that to the New York Times before she formally filed it. But that did not make it defamatory. Under California law, if you're about to file a complaint in a quasi judicial proceeding, your communication is privileged, even if you share it with the media before you get around to filing it. In other words, you are allowed to make these statements to the media before you file. The court basically said, look, this complaint, yeah, it's one sided. It makes Blake Lively look good, but that's what most complaints do. There's nothing all that unusual about this complaint. Now, as for Blake Lively's husband, Ryan Reynolds, also a famous actor, the Wayfarer party said he told a reporter that Baldoni was a predator who sexually assaulted Blake Lively, Brian's wife. The court said even if Ryan Reynolds actually said that, Justin Baldoni could not prove that Ryan Reynolds knew it was false or was reckless about the truth. If he believed it, then there was no defamation. Now, for the smear campaign allegation, Baldoni accused Blake Lively and the New York Times of conspiring to publish a hit piece. The court said the Times would only be liable if it knew that what it was publishing was probably false. But the court came down on Blake Lively's side pretty hard here because here's what the court said. The CRD, Civil Rights Department complaint and article contained numerous messages and documents strongly suggesting the Wayfarer parties did spread negative stories about Lively. In other words, that Justin Baldoni's side did spread negative stories about Blake Lively. Given the strength of the evidence in favor of a smear campaign, it is not plausible that the Times entertained serious doubts. In other words, the court seems to believe that Baldoni and Wayfarer were trying to smear Lively and that the Times had good reason to believe that. And even if it got some details wrong, this didn't amount to anything like defamation. The next area is false light. Now, that's kind of like defamation's cousin. In other words, you can sue if someone creates a false impression of you in the public eye that's offensive or that's damaging. So, Wayfarer argued that Lively's complaint against him, her sexual harassment complaint, and her statements to the press made it look like Wayfarer and Baldoni were abusive, that they were retaliatory, they were dishonest. And here's the thing, the court said, yeah, that's pretty much just defamation all over again. You're just repackaging it. And I'm going to rule that out for the exact same reason. There was no malice, there's no liability. And as to the New York Times, New York doesn't even recognize a false light claim. So there was never a chance with the New York Times. The fourth area is breach of the implied covenant of good faith against Blake Lively. This one is based on a legal principle that when you sign a contract, you agree, even without saying so, that you're going to act in good faith, that you're not going to keep the other party from getting the benefit of the deal that you just made with them. So Wayfarer said Blake Lively demanded creative control of the film, that she undermined Baldoni. She refused to promote the movie. She made false claims that disrupted production. And the court said that could, in theory, violate the duty of good faith. But here's the problem. You only get that duty if there's a contract. And the court said Baldoni doesn't show up with a contract in hand. He can try again. This is one of the claims where he has the chance to revive this. The court said if he can cite a real agreement, then that this claim may be revived. But that may be hard because apparently Lively never signed her employment contract. So if there is no signed deal, this may be dead as well. He may not be able to amend it. So the fifth area, tortious interference with contract. This is Baldoni's claim that Lively and Ryan Reynolds, her husband, got him dropped by his talent agency, which is WME. According to Baldoni and according to Wayfarer, Ryan Reynolds spoke to an executive from the talent agency at a movie premiere and said very negative things about Justin Baldoni. And shortly after that, Baldoni says his talent agency ended his relationship with them. But the court said there were a couple of problems. First of all, again, no contract was described, no contract was attached. So, what did the talent agency breach? And the complaint didn't explain how exactly Ryan Reynolds' comments caused the breakup. Did the agency say that Reynolds influenced them, or did he pressure them somehow? The court said the facts, they're just not here. And so the court did give Baldoni a chance to refile this claim if he can show there was a real relationship between WME, the talent agency, and Justin Baldoni, and that Ryan Reynolds intentionally interfered. They may be able to go on to round two. The last area, promisory fraud and breach of implied contract against the New York Times. Here's the story. When the New York Times was working on that big expose, they allegedly told Baldoni's team that they had until noon to comment. A big article coming out, you have until noon to comment. So Baldoni's team, Wayfarer, responded early, and they thought they were going to have a chance to respond again before publication. But the Times must have assumed that was all they were going to do, and it went ahead and published the article before that noon deadline. Now, the court said, so what? There was no promise. There wasn't even an implied promise. The Times never guaranteed you, Baldoni's side, Wayfarer, that you were going to get the chance to look at this in advance and approve it. And even if there had been a vague understanding, the court said, First Amendment law makes it very difficult to sue a news outlet over how it runs a story. So, in the end, no promise, no contract, and no fraud. So, what's left? The judge dismissed all of the claims that Justin Baldoni and Wayfarer had filed, but they have the chance to amend and to change two of those, and they may be able to bring those again. The first was the breach of implied contract and good faith against Blake Lively. The second was the tortious interference with WME that was against Reynolds. Now, both of those are hanging on by a thread. Baldoni has to amend, strengthen them fast, or they will be tossed for good. Right now, in fact, they're out unless he can fix the problems that the court noticed. Bottom line, this case is far from over. For one thing, all of Blake Lively's claims are still in play right now. But Baldoni and Wayfarer have suffered a massive blow. And if they can't revive these two claims, then it could be game over for their claims against Blake Lively and all of the people on her side. I'm Lawyer Lee. Thank you for watching. Please like and subscribe. I cover all the legal cases in the news, and I'll see you in the next video.